Hi, my name is Tania Shah, and today I'm going to talk to you about contracts. So let's talk a little bit about contracts as a whole and what you're going to be learning throughout this semester or throughout the year if your class is a year long. I'm going to start with a general introduction to contracts. So if you look at your first slide on contracts, contracts is about fairness. It's about equity. And it's not about punishment. Some of the other areas of law that you're going to be studying, such as torts or criminal law, may have some punitive aspects to it. That is to punish, for example, the defendant for their wrongdoing. Contracts is not about that. Contracts is really about doing what's fair, what's equal, and what's just. And in breach of contract actions, we never aim to punish the defendant. So if you look at our very first slide, what law applies, that is extremely important before you attack any contracts question, is what law applies. And by that, I mean, does the Uniform Commercial Code, that is the UCC, or does the common law apply? This is the question that we always ask first. Before we even ask questions like, is a contract formed, we want to know what kind of law governs that contract. So that's the first thing that we're going to be talking about in contracts. Second, we're going to be talking about formation. That is, how is a contract formed? And there's going to be three very essential elements to contract formation. And that is going to be the offer, the acceptance, and consideration. Those are three of the essential elements to forming a contract. And, in our first segment, after discussing what law applies, we're going to spend a good amount of time on formation. Now, after formation, we have a section on defenses to formation. That is there anything that may constitute that contract as being void or voidable? In that situation, we ask, is there any reason not to enforce this contract? And you have several areas there that speak to defenses of contracts. We have something called the statute of frauds, which speaks about those contracts that need to be in writing, infancy, illegality, contracts that are illegal, duress, mutual mistake, and fraud. Those are all issues that go to the enforceability of a contract. Next, we have to talk about the actual terms of the contract. If you know you have an enforceable contract, because we've talked about formation, we've talked about defenses to formation, if you know you have an enforceable contract, then we ask what terms apply. For example, has there been a modification or a change to the contract? Are there what we call parole evidence issues, which is something you're going to be learning about soon? And is there any ambiguity to this contract? Anything that makes the terms ambiguous or the meaning of the contract ambiguous in any way? Next, we're going to talk about, are there excuses to the performance of the contract? This is not the same as the defense to formation of a contract. Now we're talking about, is there an excuse for somebody not to perform? For example, is there a frustration of purpose of the contract? Is the contract impossible to perform? Or is the contract commercially impracticable to perform? Finally, we talk about breach. That is, there is no excuse to performance, so somebody has breached the contract. Well, the important question there is there a minor or is there a major breach, which is something that we're going to be talking about later in your contracts class. And then, as is important with any legal theory that you advance in court, what are the damages? Damages is really important in contracts because we're looking to put the plaintiff in a situation that makes him whole again. That is, how do we make it right with this plaintiff without, of course, punishing the defendant? So of the damage that we're going to talk about expectation damages, incidental damages, consequential damages, liquidated damages, reliance damages, restitution, injunctions, that is when monetary damages are not enough, and specific performance. I know it might seem like a lot to learn in contracts, but the great thing about contracts is it goes in a very systematic approach. That is, there's this natural flow in a contract from the very beginning to the end, and that's how we're going to approach contracts for you here today. In our next video, we're going to talk about what law applies.